Great. Thanks everybody for your patience. I appreciate that. Okay. So Mr. Ms. White, I understand today there was an order for reunification counseling that was entered on March 2nd of this year, where Ms. White was going to be setting up the counseling, and the order indicated that she'd be paying for the counseling, and that there was a restriction on cannabis consumption before and during that counseling sessions, and that the father would be bringing the minor child to the counseling, and there was a kind of a necessity of accommodating work schedules and scheduling things, and that the communication regarding those counseling sessions would be set up via text messaging. So maybe I can look to you, to both of you, and you can share your input of what we're reviewing here today. So Ms. White.
Your Honor, it was on me, my responsibility to call Charlotte Rosen's office, which I did multiple times. Okay. I have called just about daily. I even went in there, and it's nearly impossible to get through. And then so I met with Alex Stivey, and she even tried calling, and she wanted me to tell you that she even tried calling herself. She left a message and she couldn't even get through. So like, I'm trying, effort is being brought, effort is out there.
How many times do you think you've made phone calls or left messages? Do they have a message service? Yeah. Or?
I've left like 3 to 4 messages, and I called like 6 to 7 times, and I even went in there once.
Okay. And were you able to speak to somebody when you went in?
Not at all. Not at all.
There wasn't a receptionist?
No.
No, okay. There's not.
Okay.
It's very hard to get back to Charlotte's office. She has a locked door, and her meeting areas are behind that locked door, so you can't really get a hold of her unless she's in between meetings. I had the same problem when I tried to get the stuff scheduled when I was ordered to get it done.
Okay. All right. That's good to know. So do either of you have any ideas or suggestions on how we can move things forward as far as the reunification counseling?
I would just say put in effort to getting it done.
Let's see.
Get her in somewhere else.
Yeah, I think Ms. Rosen, she has various employees, right, or colleagues there at that office that help with things. But I guess if you can't make an initial phone contact and they don't get to give you a call back, it makes it tough to get things moving. Why don't we do this? So I'm making an assumption, Ms. White, that you started your efforts to call fairly soon after our last hearing, which was in the first part of March.
Yes, Your Honor.
Okay. Let's do this. Let's set it over 1 week. We'll set it over 1 week to the 6th of April. And then I'd encourage Ms. White to continue what you're doing, just in a respectful manner, calling and trying to make contact. And I'll see if one of my assistants could reach out and see if they could make some inroads, see if that helps at all. I'm not sure if it will, but so let me just not give myself a little note here. All right, so maybe with those both those efforts, that will help to get things dislodged and moving. But hopefully we'll get some traction here the next week. We'll be back in this next week to see if we need to take any other action or maybe take a different direction with a different person. So any questions on how to move forward with this next week, Ms. White?
Yeah, I actually was thinking maybe if we can't get through with her, could we possibly, because I know that I've looked down south, they have more counselors down there specifically for this. So maybe is it possible that we could just go down there if we have to?
Yeah, I don't think I'm going to make that decision today. I want to give it one more shot. And then when we come back next week, that may be something that we consider.
Okay.
Yeah. Mr. White, any issues on your end about the plan of action?
Honestly, I understand that it's tough to get into Charlotte Rosen's office, but if she was to wait in between her counseling appointments. Something I understand that it's not easy. I went originally the court asked me to sign the girls up for the reunification counseling. I literally exhausted. I talked to every counselor that I could in Cowlitz County, and Charlotte Rosen is the only one that does it. I did get in contact with her, but it was a scheduling issue when you guys had asked me to do it. I
Mhm.
think rather than trying to make me, because I drive for UPS, so I'm working Monday through Friday, 9 to 5. I would be if to go down to Vancouver, I would have to take days off to do that.
Yeah, and I think we can talk more about this as we
Okay.
return tomorrow. I
Next
recognize
week.
that there opens up a large can of worms when we start talking about Vancouver versus here. And I do believe that there are other reunification counselors in Cowlitz County. I think that the list has been somewhat expanded, but it's not huge for sure. All right, so let's do that. We'll
Okay.
come back next week, 9 o'clock. Thanks for your patience. I appreciate your efforts, and we'll see if we can kind of push things to get things loosened up and get a phone call back and get things moving for y'all.
Thank
Thank
you,
you
Your
for your
Honor.
time, Your
We
Honor.
should have Morgan
Okay, great.
Thompson.
Thanks for
Morgan
joining us.
Thompson,
We'll
can
see
you
you
hear
next
me
week.
okay?
Yes, I can hear you.
Okay, great. I can hear you and I can see you. Thank you. And then Jesse Hall, if you're on the line, will you state your name, Jesse Hall? Okay, there's no response there. And I see Mr. Lawrence is with us, the guardian ad litem. Thank you for being here this morning. And I believe we're on today for Ms. Morgan's, Ms. Thompson's motion related to default.
Yes.
So what I'm seeing last week in front of Commissioner Nelson, Mr. Hall was not present. He was involved in maybe some other type of hearing. Commissioner Nelson set it over to this week. He did make a comment that based on the proper service of Mr. Hall by Ms. Thompson back on February 14th of this year, that that Ms. Thompson was entitled to a default order, but he wanted to give kind of an abundance of caution and allow Mr. Hall to appear here today, setting it over 1 week. And I'm just curious, did anybody have any contact with Mr. Hall notifying him of today's hearing? Either Ms. Thompson, Mr. Lawrence?
No, I did not.
Okay.
Your Honor, I attempted.
Mhm.
I contacted his attorney in his criminal matter
Okay.
and left a message for him to get in touch with me, and I have heard nothing.
Okay, so you actually made contact with the appointed attorney in the criminal matter and told him about today's hearing.
I left a voicemail to that effect, Your Honor.
Okay. And everything seemed normal when leaving that voicemail. It seemed like it was connected with that particular defense attorney, nothing to lead you to believe that it was just kind of an open box or no man's
No,
land.
he stated his name on the message.
Okay. All right. Perfect. All right. And then, okay. So I think that's, I think that was just an abundance of caution. It looks like there was an opportunity for Mr. Hall to be present here today. You know, attorneys are, my experience has been that they're very good about conveying information, especially when it relates to a court case. They're usually pretty on top of that. So let me just double check here. I think here, Ms. Thompson, you're entitled to that motion for default. And I'm just looking through the paperwork that was presented to me to see if I have a proposed order, and I do from you. So I'm just looking over that just momentarily. Okay. And Mr. Lawrence, have you seen a copy of that proposed default order?
No, I have not, Your Honor. I understood that the parenting plan was part of the process, and so if the court approves it, I'd be asking that the court relieve me of my appointment.
Okay. Ms. Thompson, do you have any concerns with that request from Mr. Lawrence?
No.
Okay. All right. So I'm fine signing off on the order on motion for default. So that basically means at this point, there's been no response to the request that you've made, Ms. Thompson. Therefore, everything that you've pleaded and asked for, you get. However, as far as final orders, looks like there was a temporary parenting plan that was put into place, a temporary family law order, and a child support temporary order. uh, since this is a default, we need some final orders, basically
Okay.
that mimic those prior orders that were inputted. Ms.
Okay.
Thompson, is that something that you could prepare and submit?
Yes.
Okay. What would be a good time frame for you to have, so we could have a review of those orders, 1 week or 2 weeks?
1 week is probably sufficient.
Okay. All right. So we can set this matter over 1 week to the 6th of April at 9 o'clock for presentation of the orders that come by virtue of this default order that was entered today.
Okay.
And Mr. Lawrence, I'll grant Mr. Lawrence's request to be relieved from his duty in serving in this particular case. And Mr. Lawrence, is there a particular order or form that you submit, or is this a simple bench order that relieves you of your appointment?
Your Honor, I believe a simple bench order will do it.
Okay, I will prepare that bench order, and then you can submit whatever billing or what needs to be done on that end, but I'll relieve you of your duties.
Thank you, Your Honor.
Okay, so I think that completes today's activity. Ms. Thompson, do you have any questions?
No, will you just tell me the date and time again, please?
Yeah, I'd be happy to. Thursday, April 6th at 9 o'clock.
Okay, and will that be the same docket as I'm on right now?
Yes.
Okay.
Yep. Okay.
Okay,
All right.
excellent. Thank you so much.
Very good. We'll see everybody. First off, the petitioner, Garrett Alton, are you on the line today? Garrett Alton?
Yeah, I'm here.
Okay. All right. Welcome to you.
I cannot get my video to work though.
That's okay. That's okay. Ashley Keefe, are you on the line?
Yeah, I'm here.
Okay, great. I can hear and see you, and I can hear both of you well. All right. So this is on today, from what I've seen. This is Mr. Alton's motion for adequate cause and a motion to change a parenting plan. And it looks like, if I'm not mistaken, service of the papers notifying Ms. Keefe of what was being requested by Mr. Alton were served on her on the 27th of March at about 4:25 p.m. Mr. Alton, does that sound about right?
Yep.
And Ms. Keefe, does that sound about right too for you?
Yes.
Okay. So, so at this point, I have an idea what Mr. Alton wants. I have no idea what Ms. Keefe wants. She hasn't had an opportunity to submit documents to tell me what she wants. Generally, there's a lead time, or somebody's given notice of a hearing with enough time to respond in writing. And here, Ms. Keefe hasn't had enough time. So one way we resolve that is to set the case over to allow Ms. Keefe some time to respond to what Mr. Alton is asking for, and she may be opposed, may be agreed, I don't know, and then allow her to respond. So that's kind of what I think needs to happen. Does any party have any questions about that?
Yeah, can I make it noted? I've made several attempts to get her served papers on March 19th. I attempted to serve her at 2:30 and at 7 p.m. And I talked to Ashley on the phone at 3:06 and informed her that I had papers to serve. And then she was seen leaving town the next morning at 8:20 with bags packed. And she would not let anybody know where she was going. And I contacted her mom on the evening of the 20th, asking where Ashley was at, and her mom refused to let me know. I messaged her uncle, her dad, and I also made another attempt from an outside source that attempted to serve her paperwork as well. And I did not get her served until the 27th because she was avoiding everybody trying to serve her papers.
I was at the beach on a planned vacation and he hasn't talked to me in over a year almost.
She had a rescheduled.
So let me just interrupt. I recognize that serving papers and the like can be very, very, very frustrating. And we each have our own views of what the other person is doing or not doing. Here, there's a lot of backstory to a lot of different things that happen in court. Kind of bottom line here today is that service has been had. It was not given with sufficient time, so we can't have the hearing today, and that's okay.
Okay.
So we're gonna set the matter over 2 weeks to the 13th of April. That's Thursday, April 13th at 9 o'clock in the morning. That will allow Ms. Keefe to respond in a timely fashion. And then once she responds and provides copies to Mr. Alton, then Mr. Alton has an opportunity to do what's called a reply. So Ms. Keefe, there's certain timelines that you need to look up and make sure that you comply with those, thus allowing Mr. Alton an opportunity to reply to your response.
Okay, thank you.
All right, so let me just confirm with both parties that April 13th at 9 o'clock in the morning timeframe works for you. Mr. Alton, does that work for you?
Yes, Your Honor.
Okay, and then Ms. Keefe, does that date and time work for you?
Yes, it does. Thank you.
Okay, great. So we'll look forward to the submission of Ms. Keefe's response and Mr. Alton's reply if he so chooses, and we'll see everybody on the 13th and we'll address the motion. On the line today.
All right. Thank you.
Yes, I'm here.
Okay, great. I can hear and see you, Ms. Forrest. Welcome. Kenneth Clark, are you on the line today? Kenneth Clark? Okay. If you're here, Mr. Clark, make sure you're unmuted and state your name, Kenneth Clark. Okay, so I'm not seeing Mr. Clark here. Ms. Forrest is here. So this is a motion of Ms. Forrest's petition for an annulment. And so I was looking at the service as far as providing service of documents to Mr. Clark. And it looks like documents were served on him on February 17th of this year up at the Spear Lake home. What I saw was that, at least on that date in February, that Ms. Forrest was the one that served the papers. That's what the paper told me. So a party can't be the person that's serving the papers. Go ahead.
I'm sorry. The clerk of, I'm sorry.
You okay?
Clerk, the court clerk lady. I asked her, I was like, he has a very violent past of EV and assault and battery, and we've never lived together ever, and he's threatened to hurt my friends and my family if I left him.
Mm-hmm.
As long as we're married and I move in with him and his ex-girlfriend who he lives with. And I said, I don't feel safe giving him that because he's very violent. I mean, and she's like, well, we can't mail it. So you'll have to mail it and you have to pay this money to see if the judge will approve you to mail it to him. I was like, all right, well, the judge approved it to be mailed to him. And she said that court doesn't mail it. I have to personally mail it.
Mm-hmm.
And the first time she said that I had to hand it physically to him. And I said, that puts me in big danger. I mean, very dangerous man.
Okay.
And the lights went out in here. I don't know.
Yeah, I just saw that. We'll have to get a work order in.
I've been trying to keep the peace. And then during this whole period, I've been doing all the paperwork. He said he's never going to leave. And the first time we ever were arguing, I noticed his behaviors were changing. I'm a psych student at EWU, and I can't be with anybody that's in criminal behavior or in drugs. And I asked him very nicely in private, could you please do a UA for me? Just because his behavior, the dilation of the eyes, the waxy thing, he got very violent. Not physical, just verbally, very abusive, and he peed dirty. And then,
Ms. Forrest, do you mind if I just apologize for interrupting? Just a quick question. I kind of want to focus, if we could. There's a lot of information that you have, a lot of things that are happening. What I want to focus on is the service issue. And like you said, there was an order entered to allow service by mail, which seems appropriate based on what you kind of explained there about your concerns for danger and the like. So that allowed for service to occur. And then what I'm not seeing is what's called an affidavit or declaration that that somebody in fact mailed the paperwork to him. Have you submitted that document? Have you mailed the documents?
Yes, the thing is, I did mail it to him.
Okay.
Her told me that because I was curious. I said, "Are they supposed to get like a certified mailing letter?" And she's like, "No, we don't do that here at the courthouse. You'll have to mail it yourself."
Mhm.
And, so I did. I did exactly what she said.
Okay. And then did you get one of those little green receipts, or, or if it's a certified mail, they sometimes give you a receipt?
She told me I didn't. She told me just regular mail.
Yeah, and you
I-
can do that too. You can do that too.
And he came out when he got it. I knew when he got it because I live right next door, literally.
Right. Can I ask you a follow-up question? When you mailed it, so the way that the court knows somebody's done something is they submit a document or an affidavit or declaration, say, I'm so-and-so on such and such a date. I mailed these documents, and you list out the documents to such and such at this address. And I put it in the US Postal Service on this date and sent it off, and then you sign it. Did you fill out that document?
I asked the clerk, the same clerk I've been trying this since like right after we got married and all these red flags.
Right.
She's to do anything else. She said, as long as you mailed it, we have nothing else to do. And
that's true on their end. And that's true on their end.
I did tell her that I mailed it. As like, I've never done this. This man's saying.
So let me give you a bit of guidance. So it looks like earlier you filled out a document called proof of personal service. Okay. So there, it's a similar document, but this one is that you would need to fill it out and say on such and such a date, I mailed such and such documents to Mr. Clark at this address. And that's the document that I need to see is that proof of personal service. I don't have any reason to doubt that you've done what you've done, that you've mailed them. But we treat everybody the same as far as documents. So there just needs to be that proof of personal service, a document that you sign that says on such and such a date, I sent these documents, and it's a document that's signed under penalty of perjury, gives everybody pause to make sure that they're did what they actually did. But that's the one document that is lacking, and that in order for the case to move forward, I need that proof of personal service or proof of mailing filed with the court. And some of your options, you can obviously check with the clerk's office. There's also a courthouse facilitator that works at the courthouse that they can review your paperwork. So once you get that document, you can fill it out. So, and then another option is contacting legal aid. Have you contacted legal aid?
Nobody has helped. I've done everything. They're costing me so much money.
So with with legal aid, that won't cost you anything.
No, wait, and they're like, well, you got to go to the clerk for this. You can do this and this.
Mm-hmm.
And questions I don't even understand. Mm-hmm. This man just when I've never even lived with him. Never.
Right. Yeah, and what in order for the case to get going, we need that proof of service. And so you're really close. The case, you've done a lot of work and you're really close. The proof of mailing is the one thing that we need to get the case moving to the next stage. So that's really kind of the key. The proof of mailing, that's the document. I would, do you have something you could write down, a phone number?
No, I have my phone.
Okay, let me give you a phone number to call. It's called the Clear Hotline. The Clear Hotline. It's staffed by a group of attorneys. They're generally out of Seattle, and they have certain hours. They're not open 24/7, but you can call them, and they're there to provide some legal advice. And if they can't provide you with everything you need, they can refer you to a local legal aid. So the Cowlitz-Wahkiakum Legal Aid Group. And they can help you, and then they can actually even refer you to a specific attorney if needs be. But oftentimes people will just call and they'll get the information, everything that they need. So here's the phone number for what's called the Clear Hotline. And there's also a good web page that can help explain this service, this proof of mailing, proof of service. If you want to just jot this down, it's www.washington law LAW help HELP.org. So your options are to call that Clear Hotline, and you can speak with an attorney. They'll be on the phone, and you can ask questions to kind of explain where you're at in the process with your petition for annulment, and tell them that the judge said that you need a proof of service or a proof of mailing, and they'll probably be able to say, hey, look, here it is. This is what you need to do. And then you submit that, and then we get it on a docket, and then we can move forward. So that's kind of where we're at.
Do I have to mail them again?
Not necessarily. That's something that you can talk to the attorney at the Clear Hotline, what their take is on whether you need to mail the documents again. You may not need to, you may need to, kind of depending on the timeframes. Okay, so you're pretty darn close. You've done a lot of legwork. It's just that one last piece. And you've got a couple of good resources that you can fall back upon. The Clear Hotline, and then also that Washington Law Help. It's a great resource, and they may even have the form right there on that web page. So once you've got that proof of service filed with the court, then you can file a notice to put it on another docket, and then we can go from there. Okay. So any questions at this point, Ms. Forrest?
Can I go here and do the what's the
clerk's office? Yeah, certainly. You can consult with them, see if they can give you a hand. And so I guess three resources: the clerk's office, the Washington Law Help, the Clear Hotline. And with the Clear Hotline, they do have some somewhat limited hours. So make sure when you call, they'll tell you what their hours are if they're not open at that time, so you can call back at another day.
And what's the paper I need? What's it called?
It's either the proof of service, or proof of mailing.
Because I know that the judge, he granted me the mailing in, and just nobody told me.
Yeah, and it's hard because this is a new process for you and a lot of people, and it's not intuitive in any way, and it's challenging. But you're close. You're super close. Okay. All right. So what needs to happen is that contact that lawyer on the Clear Hotline, and then ask him or her about the proof of service or proof of mailing, and then submit that document to the court, and then do a docket notice, which tells everybody, hey, we're going to have this hearing at a future date. And you'd say, we're going to come back on the 21st of April, or the 14th of April. And then everybody has notice. And then when we're here and we've got that proof of service in the file, then we can move forward.
Thank you.
Okay. All right. Alrighty. Great. Good luck with everything.
Thank you. Do I leave now?
You can if you want. No need to stay on the line. Okay, great. Okay, I could see you, but I wasn't quite sure if the audio is coming through. If you could just say good morning.
Good morning.
Perfect. Okay, great. It's coming through loud and clear. All right, and then Miss Hannah Allwine, are you on the line today?
Yes, sir. I'm here.
Okay, great. I can hear and see you well. All right, so we're here today on, it looks like two motions. One is Ms. Allwine's motion for adequate cause and a motion to modify a parenting plan. And then also I see that we're on for Mr. Jones's motion for contempt for not following a parenting plan. So I think those are the two motions that are set for today's hearing. Does that sound right to both of you?
Yes.
I don't know what the contempt of court without. Baby. We're in court. You gotta be quiet.
Hi, Tyree.
Okay.
You gotta go. Sorry about that.
It's okay. So Ms. Allwine, you were stating about the contempt.
Yeah,
You weren't quite sure about that.
yeah, I just got notice of that last night. And I didn't
Okay.
even get the actual papers. I was sent to, the first page was sent to me through Messenger through his ex-wife.
Okay. All right. And then let me check with Mr. Jones as far as service of all the documents related to the contempt. Did you file a declaration of service of those documents on Ms. Allwine?
Yes, I filed it through the court. And I don't got no way of getting in contact with her because I don't really talk to people. And she been sending messages to my wife to send to me about court dates. So I just saw one. So she know.
Okay. And then, so going back to that proof of service, you heard me talk to that other case quite a bit about that. Did you fill out that what they call either a declaration of service or confirmation of proof of personal service?
No, sir.
Okay. So that's one thing that it will be necessary before we can hear your contempt motion.
Okay.
So you'll need to get that filed, stating when the service happened, and then you can have that noted up. Once you've got that in the file, then we can hear from you, and then Ms. Allwine will have an opportunity to respond to it. And so that'll be at a future date that is noted up.
Okay.
Okay. And then Ms. Allwine, you had your hand raised?
Tyree knows that I work at Chevron, so that's where he's been serving me on my papers. It's fine to serve me there if that's what he chooses.
Oh, okay. All right. All right. So that kind of whittles things down to the one motion that is noted for today, which is the motion for adequate cause and a motion to modify a parenting plan. So it looks like Mr. Jones did receive a copy of those documents back on the 14th of February. Mr. Jones, did you get those documents related to the change of a parenting plan and the like?
Yes, sir.
Okay. And then in response to that, I know you filed the motion for contempt, which we're not hearing today, but did you file any other documents that are responding to Ms. Allwine's request to change the parenting plan?
No, because I don't think see how I got my parents' plan in first. So I don't care for her to change it because I'm doing everything right. I'm not trying to like take my daughter away from her. And I just want time too.
Okay. And so what maybe I can kind of flesh this out a little bit to see if we're on the same page here. So Ms. Allwine was requesting in her motion, she proposed a parenting plan, which was back from February 13th, where she is, there's joint decision making, and that she's nominated as the primary custodial parent, and that her proposal is that your time with the child would be from Saturday at 11 a.m. to Saturday at 5 p.m. and then Sunday from 10 a.m. to Sunday at 5 p.m. So that's her proposed parenting plan. And I didn't see any documents that you submitted that told me what your position was, if you thought that was a good idea, if that was a bad idea, or something else.
Really haven't had time because I got a lawyer to deal with this right here because I don't I'm doing everything right. I'm not sitting here trying to play this back for mouse and cat game. I just want my daughter, and she want to be primary care. I don't think it's right because I'm a good father. I haven't sit here try to I get her Friday through Sunday 4 to 4. I'm giving her all the time in the world. So how is it right for her to change the parenting plan when I'm giving her her daughter, our daughter, and then her have time with her?
So thank you for that input. You mentioned that you have an attorney to help you on this case. Is that correct?
Sure.
And who's that attorney?
I'm going to Clear
Hotline. Okay. All right. So usually what I've seen with Clear Hotline is that they're really good consultants. They talk to you about the case, but they don't come to court and advocate in court. Is that your understanding of their role? Okay.
Yes, sir.
All right. So I guess where I'm at with this is that it's kind of a paper-based case that we have. So we have people file their paperwork and then we come to court and people talk about their paperwork. So at this point, I've seen the paperwork of Ms. Allwine, and I'm happy to hear from her, to have her share her thoughts, what she thinks about the paperwork she submitted. And then I'm happy to hear from you, Mr. Jones, about what you think about that, but I don't have any paperwork from which you would share your thoughts. Do you know what I mean?
Yes, I get it.
So do you plan to file some paperwork sharing your position of what you think about the proposed plan of Ms. Allwine?
Sure.
Okay.
I do.
All right. And so do you have a general idea of timeframes, how long you think that would take to get that paperwork in and when we could come back?
A couple of days, like a week.
Okay. Okay. And then Ms. Allwine?
I'm just asking that Kalia not be removed from the home since she's been in my care for the last year. And he doesn't have a proper housing. Like he said, he lived at the Oxford house. I have documentation stating that he has not lived there for several months and he's not employed. Like there's a lot of reasoning why I choose for her to stay in my home. I mean, if he wants her, you know, this weekend or today, I can agree to something like that because I know it's been a while, but I don't think just throwing her right at her dad and it's been over a year is good. I don't think that it would be very healthy for her and going to an environment that she don't know. Like she's only 3.
Okay, so let me touch base with Mr. Jones. Mr. Jones, the request is until we come back to court in a week or two, so we know what your paperwork says, that until that time, there'd be the child would stay with Ms. Allwine. Do you have any thoughts about that?
Yeah, and my thoughts on that is like, I got a steady place, I got a job, I'm going through court help. They all can vouch for me that I'm not out here being crazy. I got a stable housing. I'm doing my work, and other than she can stay with her mom until I get the paperwork in. But after that, I'm fighting.
Okay, so from what I heard you say, Mr. Jones, just see if I can summarize it, is that you're working, you have a place to be.
Yes.
Until we have that hearing, you feel okay with the child being with mom, but at the hearing, you're going to state your position and you're going to be fighting for what you feel is absolutely best for the child.
Yes, sir.
Okay. So Ms. Allwine, I think that addressed the issue that you've raised, is that you wanted until we have that hearing that the child stays with you.
Well, I'm going to
removed with you.
Yeah, I'm going to fight for her to stay in my home. I don't know if there's still a restraining order or not. I'd like to know about that also, because the reason why, yeah.
So I can take a look and see. So I'm looking in this is what we call a family law case. There may be other cases in which they've been filed and they wouldn't be connected with this case necessarily. So when I'm looking at this case, I'm not seeing any restraint provision in this case.
Mr. Jones pulled a gun on me in front of my children. This is why the judge has allowed the parenting for me to enter a new parenting plan due to the restraining order that was filed over a year ago. I don't know if it is expired because I missed the last court date due to work and sick children.
Okay, so it looks like there's a different cause number. So let me just take a look. I'll just pull it up and I can just share what the record shows as far as that other case. So bear with me 1 second and I'll pull that up. The order that was initially imposed was reissued on February 27th, 2023. And so I'll just pull up the actual document and just share with you what it says. It says, so a hearing was held on February 27th, 2023. Both parties appeared and that made a finding that there wasn't a change, but the motion for renewal filed on that date was, so the initial case was entered, the initial restraint order was entered on March of 2022. And that's,
It wasn't.
that order was entered and it was granted. And so the order on February 27th of 2023 was reissued the restraint order, and that it expires now on March 7th of 2024. I think that original order, protection order, carved out an exception that said subject to the parenting plan. So even though there's a restraint provision, it's in place that the court still has the authority to go in and form a parenting plan that's in the best interest of the child.
Yeah.
So that was kind of a long-winded answer to your question.
Okay.
So that brings us back to the service issues. So Mr. Jones, you had filed a motion for contempt. So there needs to be a service of that paperwork upon Ms. Allwine. And then we can have a hearing at a later date that you note up via docket notice. And then there's the mother's motion for adequate cause and a motion to modify that parenting plan in which you're going to be responding. And so I know what your position is and what you think is in the best interest of the little one.
All right.
So, so let's look at a 2-week time frame of April 13th. April 13th is 2 weeks from today. That'll allow Mr. Jones to file his response to the motion to change the parenting plan. That'll allow him to get service upon Ms. Allwine of the contempt. And then that'll allow Ms. Allwine to get a response to the court about any contempt motion. So she'd have an opportunity to respond. So everybody comfortable coming back on that April 13th at 9 a.m. timeframe?
Yes.
Yes.
Okay, that's good for Mr. Jones, good for Ms. Allwine. Okay. So any questions on what preparations need to happen before we come back to court?
Sorry.
Okay.
I just file papers against the contempt, or is it, I don't know.
So usually if a person is served with papers and they either agree with it or disagree with it, it's good to have a response so we know what your position is. And so you'd file some type of declaration or response to a motion and file that with the court and serve a copy to the other party.
Okay.
Okay.
Is there an address to where I can serve Mr. Jones or have Mr. Jones served, or can I do it through Messenger or what?
There's some particular rules around service. Usually Messenger is only available through a court order. So it either has to be personal service or through mail. If you do it through mail, you have to ask the court for permission to do that. So
Okay.
generally it's personal service through somebody that's not yourself. It has to be a third party, can't be a party.
Okay.
Okay. All right. So any other questions before we end the case for today and come back in 2 weeks?
No.
Okay. All right. Thank you both for your patience and participating today. We'll see you in 2 weeks. Mr. Miller?
Thank you.
Yes, Your Honor.
Okay, great. I can see you. And then I'll ask if Taylor Young is on the line. Taylor Young, are you on the line today? All right, Ms. Young, I'm not hearing you. If you are on the line, please unmute and state your name, please. Taylor Young. Okay, so I'm not hearing any response from Ms. Young. So it looks like, Mr. Miller, you filed, looks like several motions. One is a motion for a default. Second is a motion to amend a parenting plan. Third is a motion to amend a restraining order. And one thing I need to double check is the service. You've heard me talk a lot this morning about service. So let me just take a quick look at the file, make sure we're good there.
Hey, I'm almost done. We're on me right now.
Okay, so it looks like your motion, Mr. Miller, I'm seeing your motion for default was entered. Looks like you filed it back in September of 2022. Does that sound about right?
Correct.
Okay. And we had a hearing in September. There was some concern about service issues. Okay, I've got my notes here, so let me take a quick look at this. So looks like Ms. Young was served that motion for default, or she was served on the 26th of August of last year and also served on September 6th. Judge Basher found that 90 days had not transpired because it was serviced by mail. So at that time, Judge Basher denied the default order because it needed to be a longer period of time. Then on September 22nd, both Mr. Miller and Ms. Young were present, and the judge entered a parenting plan at that time. And the mother has not filed a formative response or a formal response. And it looks like it was previously denied. And so we're back on. So was there so what I'm seeing, Mr. Miller, and I apologize for kind of talking out loud, is that there was that September motion for default that you filed. It was heard by Judge Basher. He denied it because the service time periods are longer when it's mailed, and the 90 days had not yet transpired. So he denied the motion for default. And so is there a new motion for default that's on the table?
I believe so.
Okay, great. So the clerk just looked at me and gave me that look and said, look in your paperwork. So I'm looking in my paperwork now. So thanks for your patience, Mr. Miller. I do see it here, so let me take a look at this. All right, so here's the new motion for default. I've got it. Thank you. All right, so the motion for default basically indicates that you're making a motion to the court because you filed and served the other party on September 22nd with a summons and a petition. And that was at least 91 days ago, kind of what we were talking about.
Right.
And that you live here and she lives in Thurston County and the kids live here, or child lives here, and that she's not covered by the Service Members Civil Relief Act. Okay. And then did you give her a copy of, did you give her a copy or send her a copy of this motion for default?
Yeah, I believe we did it through email.
Through email? Okay.
Yeah.
Let me ask you a quick question, Mr. Miller. It looks like you filed a notice of a hearing for April 13th, this coming in a couple of weeks. What's the purpose of that? Is that the motion to modify the parenting plan or amend the restraining order?
I believe so.
Okay. So
a lot of this is just happening so fast, and I'm trying to juggle this and juggle work all at the same time.
Yeah, it's
and my
tough.
girlfriend, yeah. So I believe we're all on the same track.
Okay, so today we're March 30th, and then I see this notice of a hearing that says, hey, we've got a hearing scheduled on April 13th to talk about a motion to modify the temporary parenting plan and the amended restraining order, which I guess kind of makes sense because today you're asking for a motion for default to have the parenting plan and everything ruled with what you asked for because there hasn't been a formal response.
Correct.
And then we're coming back in 2 weeks to modify that parenting plan that we just entered today potentially and modify the restraint order. That's where I'm a little bit confused.
Okay, so there, can you still hear and see me?
I can hear you. I can't see you anymore.
Okay, so it's just to dismiss the motion for to default and go from there. Might bring up the motion, the modify on the 13th for supervised visitations.
Okay.
Did you get that?
I think I got that because in your initial pleadings, you asked for a particular type of relief, and with a default, you can't change. Like, okay, now I asked for this, and I'm changing it. So you get what you get what you asked for if you went on the default, and then if you want to change that, then you'd come back on April 13th to modify it.
Okay, yeah.
Is that what you're thinking?
Yes.
Okay. So that makes more sense to me after having explained that to me. Let me just go on the initial motion here, your parenting plan. So here back on August 9th, you filed a parenting plan, a proposed parenting plan related to, is it Malaya?
Yes.
Okay. And it states that you're asking that there be limited decision-making, that you'd be in charge of school, education, and healthcare decisions,
Yes.
and that you would be nominated as the primary custodian, and that she would have, Ms. Young would have visits on Friday at 6 p.m. to Sunday at 6 p.m. every other weekend.
Sounds right.
Okay. And then you've got some holiday schedules set in there, and that the exchanges would be up in Toledo. All right. So that's what you're asking for. Okay, good. I think, thank you for your patience and helping me work through that. I appreciate that. Mr. Miller, has Ms. Young appeared at any of the hearings since the case has been filed?
Yeah.
So one thing that I was looking at on your proposed order for the default, it says, it's talking about notice for Ms. Taylor or for Ms. Young. It says the other party, Ms. Young, is entitled to notice of this motion for default because she appeared or was served with the summons more than a year ago, which I don't think that's accurate because it's not been more than a year. So the other option is that she's not entitled to notice of the default motion because she hasn't filed a notice of appearance and she has not appeared in this case in any other way and was served with the summons and petition a year ago. So I'm a little bit concerned that since she has appeared in the case, usually a default is like the other party says, whatever, or they don't contest what you're asking for. And so they don't show up for anything and just say that what that person wants, I'm okay with that. Here, what she's, go ahead.
I think she was more kind of explaining like she hasn't responded to the case. So like she's not there.
Right. She hasn't formally responded.
Right. So I think that not more or less like she hasn't showed up to the case, just more or less like she hasn't responded. Like she showed up to court multiple times, but just never responds.
Right, right. And it looks like the contempt issue has already been decided. So we don't need to decide any contempt issues today because that was decided back on the 16th of March. Okay. Have you, that when we're talking about that hearing on the 16th or on the 13th, did you send her a copy of that notice for the hearing on the 13th?
Yes.
Okay. And then did you send her a copy of today's hearing or
I did.
Notice of that?
Yes, I did.
So the one thing, Mr. Miller, I'm inclined to grant the motion for default if I have a showing that she was given notice of today's hearing. Do you know if you filed some type of proof of service?
Well, so like, was this hearing scheduled from the last court date?
Good question. Let me check.
Because if that's the case, then she was most definitely aware.
Okay. Yeah. Let me look. Last hearing was on March 16th. So I'll pull up the minutes from that date. She was present. You were present. And the court set the default hearing over to today at 9 o'clock. Court denied the contempt, rules on medication, third-party communication, disparaging remarks, sign a bench order. So that was done. And she was present and we set over the default to today. There was quite a bit of discussion at the last hearing about the default. And she was present with the limited legal technician, Ms. Balcher. Yep. And the court set the default out to the 30th today. And then y'all talked about the contempt, not providing school clothes, visitation, Commissioner Cotterell, child support. Okay, so all that. And that set it over for today. And usually when a case is set over, the parties are present and there's an indication that this case is going to be discussed today and that something would be filed. So I'm going to say that there was
she
notice.
was aware.
Yeah. I think that's true. So thanks. Mr. Miller, the clerk kindly pointed out to me that on March 27th, it looks like Ms. Taylor filed a response to the parenting plan request. And she indicates that there's agreement in some portions and there's disagreement in other portions of the proposed parenting plan. So
Right.
I think that puts us at a position where that since she's responded, the motion for default is, I think I need to deny that since she filed a formal response. We still have the hearing set on this coming 16th or the 13th, I think it is, the 13th, to address the parenting plan.
But I mean, she's still not here today.
She's
So
not.
that's now we go back on that question of you asking me, like, what do I mean by how she's not present in court? This is a good example of how she's here, but she's not here.
Right. There's kind of a pattern of not being present.
Right.
Yeah.
So I mean, like, and that's what I've been fighting this whole time.
Mm-hmm.
That's why my end is being prolonged.
Yes. Yeah. And I can't disagree with you. I think here that the fact that somebody doesn't show up to court is somewhat frustrating. With the default, it's a little bit different because with the default, basically there's not a formal response, and that's what the court's looking at. Because sometimes people just say, I don't care, do whatever you want, get whatever order you want, and then the court do that. But that's not the case here. So she's filed a formal response which says, okay, there is something in dispute, that the two parties have divergent views on what should be the outcome of the case. So since she's filed that, and it would be very good if she were here, but she's not. So I think that's enough to deny the motion for default, simply because the court looks for at least some formal acknowledgement that there is a dispute or there's not a dispute. She's saying there is a dispute. Okay, so that means the case goes forward. So if with the docket notice sent out for the 13th, then we'll be here on that date to consider the motion that you filed.
Okay, I want to put on the record that she was not here today, though.
Yeah, clearly.
And it follows a pattern of her.
Yeah.
Okay.
Yeah, that's fine.
Okay.
Yeah, the clerk's minutes they always reflect who's present and not present. It'll reflect that Mr. Miller is here, and Ms. Young is not here.
Okay.
Notwithstanding the notice that she had that we were going to send it over to today, she's not present.
Sounds good to me. But so nothing's changing though on my end.
Right, as far as the motion
until the 13th.
Right.
Okay.
Yep, that's I think that's an accurate portrayal.
Okay.
Okay. All right.
Yes,
thank you, sir. I see to you also. So we're here today, it looks like, on a motion related to let me get my notes. Child support, child support. And this is a motion related to the support of 3 children. Just preliminarily, I understand that there is currently a what we call a 50-50 parenting plan, where it's a roughly even split of parenting between the parties.
Yes, Your Honor. There's one question I had about that. I didn't get to it on the 15th because Shanice had just given birth to her new child and it got postponed. The parenting plan wasn't an agreement at all. It was an old parenting plan that we had an agreement, and she whited out a bunch of stuff and then submitted it to the court with the signature page from January.
Okay.
That's not true at all.
So let me take a look, because when I looked at the case previously, I was under the assumption that I saw that there was a parenting plan in place. So I'm looking at March 9th of 2023. I'm looking at a parenting plan signed by Commissioner Nelson. It was signed on the 8th of March, and it indicates it's a final parenting plan order, and it states that the custodian is Shanice Lovato, And it shows with the school-age children that the children will switch week on and week off with each parent. This will start when the picking up parent picks the children up at school on Fridays. And it'll be Friday at 2 p.m. to the next Friday at 1:59 p.m.
Yes, those were the only thing that wasn't in agreement was the custodial parent role. We had not agreed upon that, and that's why up until in March there was no agreement. And if you look at the signature page on that parenting plan, my signature is from January 24th.
Yep.
When we had an agreement, but she said that she wouldn't submit it because she changed her mind. And, and I was under the assumption that parenting plan was thrown away, and because we still hadn't had an agreement. And then I went to court to go drop paperwork off, and the clerk said there was already a parenting plan in place, an assigned order, which there
That's
shouldn't have been.
not true. That's not true. And I have text messages proving otherwise.
So let's focus on the record here, because that's kind of controlling at this point. So I do see that a parenting plan was signed on March 8th by Commissioner Nelson. I'm going back a little bit before that at a hearing that was on February 23rd to see if there was discussion related to that parenting plan. So there was discussion about a parenting plan. Both parties were present. It indicated that Ms. Lovato said that they were working, that everybody's agreed on the parenting plan. We're ready to submit it. Mr. Lovato indicated we're still working on a few issues. And the court responded that the agreed parenting plan will be signed ex parte, which means not in court. Then Ms. Lovato indicated that the remaining issue is child support. So thereafter, the court instructed Ms. Lovato to submit the parenting plan and mark the issue of child support as reserved, and asked if you'd exchanged financial information. So there was discussion at that point in time that the parenting plan would be signed by the court, and the court did in fact sign it on March 9th. So it sounds like that may be different or a surprise to Mr. Lovato.
Yes, because I didn't find out until just after it was signed when I went to the court to submit documentation, and they said it was there. And when I looked at the paperwork, my name, because in the initial document had my name as the custodial parent, and it was whited out. And then she wrote hers in with
We
pen.
never agreed.
So hold on. Just one clear rule that I try to adhere to in my courtroom, especially on Zoom, is that when one party's speaking, there not be interruptions of that party. So if you could just abide by that, that'd make the hearing go a little bit easier for me. Mr. Lovato, go ahead.
Yeah, and so like the parenting plan that I always give her when we're going over, and they're always all typed up on the computer, and everything that she changed was whited out, and then her name was written in there. And if you look, the parenting plan was signed by me on January 24th and given to her to turn into the courts, and she refused to sign it at that time. And then she went back and used that same old one on March 9th or March 8th, whenever she submitted it, and then signed it that day. And we were working on a new parenting plan. That one was supposed to be thrown away, and that had my signature on it.
Was it the agreement of the parties that it'd be a 50-50 plan?
Yes, everything was agreed upon other than the custodial parent role.
Okay, all right. So for purposes of today, excuse me, we're talking about child support. I understand that there's some concern about the parenting plan, some as far as the custodian. But the kind of the core of it is the 50-50 plan remains and would remain, notwithstanding who's the primary custodial parent and any issues related to how that came to be. So that means for today's hearing, we're talking about child support, that even if there's to be a change of the custodian, the 50-50 plan would not change. And because that would not change, then I think we can move forward with the child support issue today.
Yes, Your Honor, we can.
Ms. Lovato?
Yes.
Okay. All right. So in looking over the paperwork, pardon me, that was submitted by the parties, this is what I'm showing, that Mr. Lovato has retirement benefits, or VA benefits, if you will, of approximately $4,604, and then a disability payment of about $1,519. Does that sound right, Mr. Lovato?
Yes, it is.
And then I showed Ms. Lovato, you submitted a 2022 W-2 form that showed you had earned $6,796 in the 2022 tax year. Does that sound right?
Yes.
Okay. And then Mr. Lovato, you're asking that Ms. Lovato be imputed at an income of $3,000 per month for purposes of calculating child support. Is that your position?
Yes, that's what she was. That would be what her hourly or her wage would be monthly if she worked her normal hourly wage.
And is that gross or net?
That'd be net.
Okay. So
Or no, sorry, gross. Sorry, gross before everything taken out. Yes.
Before taxes.
Yes.
Okay. And then, so that's kind of the parameters of where we're at. So I'm happy to hear from the parties on the issue of child support. And I didn't note who was bringing this motion. Who is the moving party?
I am.
Ms. Lovato, I will hear from you first.
Okay. So our oldest daughter, which is our 14-year-old, I have 100% of the time. He doesn't get her at all. She stays with me 100% of the time. I have 100%. I am the one that feeds her. I'm the one who buys her the clothes. I'm the one who does everything for her 100% of the time. Our other two have been going back and forth between us two. I mean, I still support them. I still, and I don't have a job right now. I'm unemployed. I just had a baby 2 weeks ago. I've been unemployed since August of last year. I guess another thing it comes with the child that I just had, since we are still legally married. I just was told by the doctors that he has a form that he has to fill out, or he is financially responsible for my new baby as well. And I'm actually not even allowed to get him on insurance right now because he has refused to sign that document.
Is that the denial of paternity document?
Yes.
Okay. Yeah, because there's a presumption. There's a presumption that if a child's born while two people are married, that the two people are married, that's their child.
Correct. Yes.
Okay.
So he's actually in the NICU. He's been in the NICU since he was born. And they actually won't even let me take him home until he has insurance and he has a doctor. And unfortunately, I can't find a doctor without insurance. And so me trying to get him insurance, they automatically try to put him on the father's, which they think is Brandon. And he would have to submit things to TRICARE to even get him officially insured. And so it's a mess.
So tell me, when you were working, what was your hourly wage and what were you doing?
So I was a caregiver and I made 17. I think it was 17 because I know we were getting COVID pay, but then that stopped right before I stopped working. So I think it was 17 something. I can't remember exact pay.
And that was after the COVID pay was lifted?
Yes.
Okay. And how many hours a week were you working?
Oh, not very many. I was working maybe at most 10 hours a week.
Sorry, there's a little audio interference. I didn't quite hear how many hours.
Oh, sorry. I was working maybe 10 to 12 hours a week.
Okay. And then as far as your future plans, as far as work, what are your future plans for work?
I'm gonna try to go to school. I'm gonna try to get into schooling since I just had a baby. I don't have daycare or anything like that for him. So I'm gonna try to go to school.
Okay. All right. Do you have any input as to Mr. Lovato's income that he stated in his motion?
So our girls also get Social Security as well on top of that. And that's literally all I was asking for him. I wasn't asking for anything outside of that. They get, I believe it's $300 each kid a month. And that's literally all I was asking for from him, was literally just the girls' Social Security.
So each child receives $300 and there's 3 children, so it's $900.
Yeah, it's roughly about that. Yeah.
Okay. And what's the basis of the Social Security payment?
I believe it's because he is retired, and so they get like the portion of it. But when we were living together, it came under my name. So it was like Shanice Lovato paid to the kids. And it went into our joint account at the time. And since we're now split, it still continues to go into his account.
Okay. All right. So that's the amount that you're asking for child support.
Correct. Just the girls with Social Security.
Okay. All right. I'll hear from Mr. Lovato. What's your vantage point on incomes and all that?
Start from the very start. To touch base on the incomes. Yeah, my income is accurate. Her income, she has on multiple documents submitted that she makes $3,000 a month for the purposes of getting like housing and stuff with her fiance. As far as the work, her work hours are as a home health care aide. It depends on how many clients she chooses to accept, and she can accept more hours, but she chose not to accept less because of for whatever reason it was on her at that point, because she has had a job where she's worked full-time hours and she cut it back as she wanted. As far as the Social Security goes, it's $250 a month per kid. Each one of them get their own, and it was going to Shanice. It was underneath her name as the payee towards them until she was out of the home and still using it to pay for hotel rooms for her and her fiance to stay in. And that's why I got it changed to be me as the payee, because the money wasn't going towards them. It was going towards those purposes. And so now the money does come through my name for the girls.
Okay. All right. And then,
Your Honor, I can prove that to be untrue.
All right.
And as far as her supporting the girls, she had Courtney full time since December 5th or 4th, and but prior to that, from March until December, I had all 3 girls 100% of the time.
Okay, and Courtney's the 14-year-old, correct?
Yeah, she's the 14-year-old.
Okay, all right.
And currently, she is not coming to my place because just from moving back from Alabama with the girls, I'm still rebuying all the furniture, and that includes her bedroom set. And that's why she has not come over. She said when she has her bedroom and once she has everything there, then she would come over. But right now she doesn't have that, so she doesn't want to come over, which is understandable.
Sure.
Your Honor, that's also untrue. And there's multiple text messages from our 14-year-old and ignoring him. And it goes deeper than just furniture. She actually absolutely does not want any relationship with her dad at the moment due to certain things that he has currently have done previously. And I mean, I could put text messages after text messages to prove that's also untrue.
Okay.
She wants to stay with me 100% of the time.
And then let me ask, the Social Security benefits that are the girls, that belongs to the girls, or is
Correct.
it paid? Is it paid
Correct.
to the parents for the child's benefit?
It's paid to the parents for the child's benefit. And I even told her before, like I have no problem giving that directly to the girls, putting in an account that she can draw from for the girls. I don't care. Like that I have no issue with that at all.
Okay. So you're comfortable if that was to be put into an account, like maybe a joint account with the mother?
Yes.
For benefit of the child?
And that's what I agreed to, since we were doing 50-50, and that, it's an agreement that I'd be providing daycare or watching our kids while she's at work or going to school. So I'll have them majority of the time while she does do those. And so I had no problem just still putting that away into a different account that we both had access to just for the girls, for any expenditure that they had, or clothes or sports or whatever it was. And she just told me that she wasn't willing to agree to that.
Well, since I have Courtney 100% of the time, she's a teenager, and I've had to literally pay for multiple things for her. I'm going to start saving receipts at this point, because I mean, I have to, every week I'm going through food because she's a teenager, and I also have the other two girls that are here. So I'm having a grocery shop every single week. That bill is like $600 a week, and I'm not working at the moment. So,
Can I ask you a question, Ms. Lovato, about that, about the account? Mr. Lovato's indicating that the $750, which is, the three children, the $250 each, that he would place that in an account for the children that is controlled by, sounded like Mr. Lovato is proposing the both of you.
and that would be fine.
Okay. All right. Then there's a provision in the law that talks about a residential credit. A residential credit, I'll just read it to you all. It says the court may deviate from the standard calculation of child support if a child spends significant amount of time with the other parent who's obligated to make a support transfer payment. The court may not deviate on that basis if the deviation results in insufficient funds in the household receiving the support to meet the basic needs of the child. And the court says when determining the amount of the deviation, the court needs to consider the evidence concerning increased expenses to a parent that makes support transfer payments resulting from the significant amount of time that they spend with that parent, and shall also consider the decreased expenses to the party who's receiving the support. So there's what they call a deviation based on amount of time that a particular child is spending with the parent. So do either of you have any input on that? Because, I think I have your basic, I have a good idea of what your incomes are, what your positions are, what the other party's income should be. Do you have a position about this deviation or this residential, what we call a residential credit? Because at least two of the children are spending half time with each. It sounds like the older girl, at least since December, has been with mom 100% of the time. Prior was with dad.
Yes.
So any input on that residential deviation credit or
no?
I mean, not really. I mean, I think given the fact that I had them for a majority of the time last year, and then she's kind of had Courtney majority of the time since December. I mean, I'm not opposed to whatever you decide.
Okay. All right. So all right. So let me just hear if I think I'm ready to give you my decision, but I just want to give each party just a final chance to talk about the child support, anything that you feel may have been misstated or you need to clarify related to incomes or the support payments.
Yeah. So also, since I have had my son, I do also get TANF, and I was just terminated from that because they're trying to go after child support for Brandon for my son now. And so I just had to terminate that because I'm trying to be somewhat like, I'm trying to be civil with him. And I know that would be wrong to make him have to pay child support for a child that's not his. But he has to sign the paper. Like, that's the thing. Like, he needs to sign the paper before DHS actually ends up going after him for that money.
Any thoughts on that, Mr. Lovato?
Well, I mean, I went down to the hospital to sign it, and then tell the nurse and the security guard and the social worker pretty much treated me like I was a criminal for even walking in there, even though by law I'm technically the presumed father, even though I got treated like I was not allowed to be there, which really upset me and caused more problems and ended not getting signed. I have no problem signing it. It was just under the circumstances, it was really frustrating and kind of it's just an emotional point for that.
Sure. And I think that if the parties need to gain access to that particular form, I think one resource you can turn to is the Division of Child Support. So they're a division of the local prosecuting attorney's office. There's an Amy Powers that is one of the senior attorneys over there. That's one option. You could contact them, the Division of Child Support, through the local prosecutor's office. Amy Powers is the senior level attorney there, and likely she would have some type of the proper form if you need that as a resource.
Okay.
So related to the incomes. So I think Mr. Lovato's income is fairly straightforward. The gross is 5820 with a net of 5670 when you add the disability and the VA income. The mother's income is a little less clear in that the W-2 shows reduced earnings during 2022. Ms. Lovato just recently gave birth to a child that it sounds like both parties agree is not the child of Mr. Lovato, and that she was working, earning roughly 1750, somewhere in the 17 range, and was working between 10 to 12 hours a week. Mr. Lovato counters that income could be augmented or increased based on the number of clients that Ms. Lovato takes on. So here I'm going to make so I've made a finding as to the father's income at that 5820 gross and 5670 net. As far as the mother's income, I'm going to impute her at an income of $2,500 per month. And that's based on a finding that she's underemployed. And I recognize, having given birth, I'm not, anybody that gives birth should be given plenty of time off from work to recuperate and to bond and readjust to life with a new human being on the planet. So I'm taking that into account. The underemployment finding doesn't come from that. The underemployment finding comes from all of 2022 of only $6,700 was earned. There's been no showing that Ms. Lovato is in any way incapacitated or suffers from a disability that would prevent full-time employment. So that's the basis of my finding of the underemployment. So when you put that into the support calculator, and this is going to be adjusted a little bit because I adjusted what I was initially going to impute mother at 2,700, but I've changed that to 2,500. So I've reduced a little bit, but these support numbers that I gave, and I should probably just do it right now while you're on the line. So give me just a second to punch in those numbers and tell you what the precise numbers are. That puts a combined monthly income of 8,170 and puts a proportional share of income at 69% or 70% and 30% respectively. And that would put Mr. Lovato's child support obligation at $895 and Ms. Lovato's child support obligation of $395. Since the children there's kind of a split between the homes, at least with two of the children. The older child is 100% with mom. So in essence, it becomes one child that is basically, so I think the older child and one of the younger children, because one lives 100% with mom and one is 50-50 with both parties, I take that into consideration. And then the other child who's 50-50 between the parties to come to a transfer payment between the parties. So I'm basically kind of making a finding that even though there's that 50-50 split, mother is incurring additional expenses because of Courtney being with her 100% of the time. Certainly, Mr. Lovato is incurring expenses because he has the two other children 50% of the time. And I also take into consideration that there's an allegation that there's another income earner in the household where Ms. Lovato is living, and I'm assuming that's the new baby's father. So I'm going to order a transfer payment of $420 from father to mother as a child support payment per month. And then I'm also ordering that a joint account be set up for each child for the Social Security benefits or the monies that come in each month. And then the parties can distribute that as they see fit for the benefit of their children. So that's the court's ruling. Does either party have any questions or points of clarification?
No, Your Honor.
No.
Okay. So with that being said, I'm proposing that Ms. Lovato, you are the moving party here. I noticed that Mr. Lovato had filed a lot of documents, at least looked like a familiarity with the child support calculator of who would be in the best position to prepare the child support order and worksheets. And if none of you feel terribly comfortable with that, then I can do that. But I just wanted to give that option to the parties.
Maybe I think it would be best if maybe you did that one.
Sure.
Because I'm not really familiar with it at all.
Sure. Mr. Lovato, are you okay if I were to prepare those documents?
I'm completely okay with that, Your Honor.
Okay. All right. So I should be able to get those out today. And would you like me to email those documents to you so you have a copy of them today?
Oh, yes, please.
Mr. Lovato?
Yes,
okay.
Yes, that'd be great. Thank you.
Do you, some people have concerns about sharing their email at Jovial, I guess, and then Lovato, Lovato @gmail.
Correct.
Okay. I will get those out to the parties this afternoon. Any additional questions or points of clarification?
No.
Mr. Lovato?
None, Your Honor.
Okay. All right. Thanks to the party. I appreciate the both of you. I will get that order out and have a good afternoon.
All right. Thank you.
You too, Your Honor.
Thanks.